Okay, good morning, good afternoon, good evening, true northers, wherever you may be. I am here today to talk about the memorandum that we submitted to the Clerk of the National Assembly to do with the Military Veterans Bill 2022. So I'll start with the good stuff. In accordance with the provisions of Article 118 of the Constitution and Standing Order 127 in brackets 3 that speaks on public access and participation, we, as True North, have undertaken a review of the bill and hereby submit our representations on certain provisions of the bill as follows. Today is one of those days I just let you look at a bit of art therapy. So we begin with number 1, section 2, which is the definition of a child. So the current provision says that a child means the unmarried biological or adopted child of a military veteran who has not attained the age of 18 years of age. Our proposed amendment in the definition of a child is that it is one who is unmarried or who has not attained the age of 18, contravenes Article 27 in bracket 4 of the Constitution on discrimination on the basis of age and marital status. That's our stand. We propose that the definition of a child of a military veteran simply mean that a child is one who is biological or adopted by the military veteran, period. Number 2, section 2, the definition of defense counsel. Defense counsel, which means the defense counsel established under Article 241 in brackets 5 of the Constitution. Our proposed amendment. Reference to the defense counsel or any and other offices under the Kenya Defense Act 2012 KDF Act makes the bill fail to distinguish military veterans' rights and legal status from that of active service members. The KDF Act at section 4, read together with section 27 in brackets 1, provides that service members who have been discharged cease to be subject to the provisions of the KDF Act. The bill does not seem to take this into consideration, as it puts the affairs of military veterans in the hands of the Defense Counsel, an entity primarily responsible for the overall policy, control, supervision of the Kenya Defense Forces, and which consists of active servicemen, together with the Cabinet Secretary responsible for defense and the Principal Secretary in the ministry responsible for defense. The Defense Counsel has no representative who is a military veteran, and therefore it is not possible to establish such an entity to properly articulate the affairs of military veterans. We propose that in place of the Defense Counsel, the bill introduces an entity to be known as the Kenya Military Veterans Affairs Council, to be established under the office of the President and whose composition shall include military veterans, members nominated by the office of the President and approved by Parliament, as well as a representative of the Defense Counsel for a balanced and representative entity that is capable of managing the affairs of military veterans. Reference to the Defense Counsel should be deleted throughout the bill and replaced with Kenya Military Veterans Affairs Council. Section 2, the definition of a dependent. It reads that a dependent is one in relation to a military veteran, means a spouse or a child of a military veteran. We propose that the definition of a dependent be extended to include such other persons as are being maintained by the military veteran, including his or her parents, brothers, or sisters. Number 4, Section 3D. The principal objects of this Act are to establish the Defense Forces Retirement Home. It is important to point out that military veterans are spread out in all areas of Kenya, and military veterans not all military veterans may be in need of a Defense Forces Retirement Home, given that most can still be reintegrated and rehabilitated into society as productive civilians. We therefore propose that reference to Defense Forces Retirement Home be deleted and be replaced with military veterans centers to be established at county levels. Military veterans from all areas of the country will be able to conveniently access the services under the bill if such services have been devolved. It will be easier, cost-effective, and more beneficial if military veterans, sorry, that skipped, and I don't want to make things up, just hold on. So let me just take that again and say, we therefore propose that reference to Defense Forces Retirement Home be deleted and replaced with military veteran centers to be established at county level. Military veterans from all areas of the country will be able to conveniently access the services under the bill if such services have been devolved. It will be easier, cost-effective, and also more beneficial if military veterans are provided with skills training, care for post-traumatic stress, and thereafter reintegrated into society through military veteran centers, as opposed to sending all military veterans to a Defense Forces Retirement Home. Therefore, Section 4 in brackets 2 in brackets B of the bill sets out the aims of the military veterans policies, and the aims that have been listed cannot be achieved by use of a Defense Forces Retirement Home. Number 5, Section 5, this Act should not be deemed to entitle a person defined as a military veteran under this Act or that person's dependent to any benefit conferred under this Act or any other written law merely on the grounds of such definition. What we say to that is that the purpose of this section is not clear. The section is arbitrary, as it does not set out the acts or omissions that would result in exclusion of a military veteran from enjoying the benefits of the bill. A veteran is a Kenyan with a military service number and has provided military service. This is our stance. This section, as currently drafted, can result in discriminatory application contrary to provisions of Article 27 of the Constitution. Any person who qualifies to be a military veteran should be treated as such, irrespective of race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, dress, language, or birth. The section also contradicts the guiding principle of the bill that sets out in Section 4. We propose that this section be deleted. Number 6, Section 6 in brackets 2. The bill says that provided that if a person suffers from a physical or mental disability that was self-inflicted or occasioned by the use of narcotic drugs or psychotropic substances, that person shall not be considered a military veteran for purposes of this Act. What we say is that this provision, the provision of the bill, violates Article 27 in brackets 4 of the Constitution, which prohibits the state from discriminating directly or indirectly on grounds of health status. The provision criminalizes and punishes military veterans who have suffered mental illnesses as a result of their service. The guiding principles of the bills are set out in Section 4.1, including recognizing the services provided by military veterans and the honor and the benefits and as a result of service to the country should not be withdrawn by virtue of a veteran being physically or mentally disabled, irrespective of the cause of such a disability. We therefore propose that Section 6 in brackets 2, paragraph 2, and the related Section 6 in paragraph 3 be deleted in their entirety. Number 7, Section 7 in brackets 1 reads, the bill reads that subject to the provision of this act, the following benefits may be conferred to a military veteran. We propose that the phrase may be conferred to a military veteran be deleted and replaced with the words shall be conferred on a military veteran. Section 8, number 8, Section 7 in brackets 1, the benefits. We propose that a new subsection 7.1, 7 in brackets 1, in brackets G, be inserted, allowing military veterans to register and immediately start receiving benefits under the Defense Forces Medical Insurance Scheme. We propose that the Defense Forces Medical Insurance Scheme and the Defense Forces Old Comrades Association be absorbed by the Military Veterans Affairs Council. Number 9, Section 7 in brackets 2. The bill reads, subject to the provisions of this act, the following benefits may be conferred on a military veteran's dependent. Once again, we propose that the phrase may be deleted and replaced with shall be. Number 10, Section 7 in brackets 4. The bill reads that any government, ministry, department, or agency that is responsible for the payment or provision of a benefit under this section shall cooperate with the ministry responsible for matters relating to military veterans in respect of the payment or provision of the benefit. We propose that for the purposes of clarity, they referred to government ministry responsible for the payment or provision of a benefit be specified as the Ministry of Finance and the National Treasury, and matters relating to military veterans fall under the office of the President and not an unspecified ministry. Number 11, Section 7 in brackets 5. For the purposes of subsection 4, the bill reads that the principal secretary in the ministry responsible for matters relating to military veterans may, in consultation with the cabinet secretary responsible for matters relating to finance, enter into service level agreements with a relevant government ministry, department, or agency for the facilitation of the payment or provision of benefit under this section. Our proposal is that reference to the principal secretary in the ministry responsible for matters relating to military veterans shall be amended to refer to the office of the President. Number 12, Section 9 in brackets 1. The bill reads that there shall be a director of military veterans who shall be appointed by the Defense Council. In line with our earlier proposal, the Defense Council should be deleted throughout the bill and be replaced with Kenya Military Veterans Affairs Council. Further, the section should be amended to specify the appointment of the Director of Military Veterans shall be done using an open, competitive, and transparent process. Number 13, Section 9 in brackets 2. The bill reads that the director shall serve under the supervision of the Chief of Defense Forces. What we are saying is that by making the director subject to the Chief of Defense Forces, the bill disregards the separation of military veterans from active service members. Service under the Chief of Defense Forces is service under his command. among the cardinal principles of the Kenya Defense Forces is that the armed forces depend upon strict discipline to function efficiently. The section would therefore defeat the purpose of management and operation of military veterans affairs being independent of management and command of active service members. We therefore propose that reference to the Chief of Defense Forces be deleted and replaced with Kenya Military Veterans Affairs Council. Number 14, Section 9 in brackets 3, the Defense Council may revoke the appointment of the director or redeploy the director. That's what the bill reads. Once again, as we proposed earlier, reference to Defense Council should be deleted and be replaced with Kenya Military Veterans Affairs Council. In addition, the reference to redeployment of the director should be deleted. The Director of Veterans Affairs is not a service member under the command of the Chief of Defense Forces or be capable of redeployment. Section 11, we propose that the bill be amended to provide for the establishment in every county advisory committees to be known as county advisory committees composed of military veterans at county level who shall be responsible for providing comments, proposals, and forwarding concerns to the National Affairs Council. The county advisory committees can be responsible for localizing the services that are offered by the advisory committee. Section 16, Section 11 in brackets 4. The bill reads, in making appointments under subsection 2, brackets B, the Defense Council shall ensure that A, not more than 2/3 of members of the Advisory Council are of the same gender, and B, at least one member shall be a retired senior officer, junior officer, and service member. We propose the inclusion of the following additional appointments criteria. C, at least one member be a dependent child or spouse of a military veteran. And the Advisory Council have at least one veteran from the Army, from the Air Force, and the Navy. In addition, for the purposes of consistency throughout the bill, we propose that references to the Advisory Council be amended to Advisory Committee. Number 17, Section 12A, a person shall be qualified to be appointed as the chairperson or member of the Advisory Committee if that person, in the case of chairperson, is a retired general officer of the Armed Forces or Kenya Defense Forces. Again, the bill fails to distinguish that this is intended for retired servicemen and women. We propose competency should override prior military ranking. We therefore propose that the provision be amended to remove the element of prior service ranking. That is, that the chairperson be a retired general officer. Number 18, Section 12, in brackets D. The bill reads, has not acted in a manner that is prejudicial to national security since the end of his or her military services. What we are saying is that this section is ambiguous. It is not clear what would be deemed to be prejudicial to national security. We propose that this section be deleted since it is open to abuse. Number 19, Section 21 in brackets A. The Defense Council shall establish a fund known as Dependents Education Fund that provides scholarships for education of children of A, members of the Kenya Defense Forces and military veterans, and B, deceased members of the Kenya Defense Forces or deceased military veterans. what we are proposing is that this section should be amended so that the education fund caters for children as well as dependents. Further, the bill is intended to cater for affairs of military veterans and not active service personnel. Introduction of dependents of active Kenya Defence Forces into the bill creates confusion and contradicts the principal objects of the bill. We therefore propose that references to members of the Kenya Defence Forces in Section 21A be deleted entirely. Number 20, Section 22, in brackets 2, in brackets A. The bill reads that the Defense Council shall prescribe regulations for the achievement of the objects of this section and notwithstanding the generality of the foregoing, the regulations may provide for A, persons who shall be eligible to reside in the Kenya Defence Forces retirement home. We propose that Section 22, in brackets 2, in brackets A, be deleted because as long as one qualifies to be a military veteran, they should not be excluded from enjoying benefits that come with having served this country. All military veterans should be eligible to enjoy all benefits under the bill. The clause as currently drafted is exclusionary and potentially discriminatory. Number 21, Section 23. The Defense Council may make regulations generally for the better carrying out of the provisions of this Act. That's what the bill reads. We propose that the Act sets out a definite time for publishing of the regulations and makes it mandatory that the regulations be published. Having a defined time frame for introduction of the regulations would be critical to the operationalization of the Act. 3 months for the establishment of the Kenya Military Veterans Council, 6 months for the establishment and operationalization of the advisory committees, and at least within 3 years, all counties to have an operational Kenya Military Veterans Center. That's what we propose. We understand that due to COVID measures, we only had the opportunity to send in our memoranda and not have a physical sitting. But we are hoping now with the lifting of COVID measures that the Committee for Foreign Affairs, National Security and Defense will consider inviting Kenya military veterans to physically show up for a sitting for the purposes of the co-creation of the Military Veterans Bill into Law 2022. So, ladies and gentlemen, that is it. That is it. Thank you.